Lordship, I'd like to mention item number 4. In this case, Lordship, respondent number 3 has been transferred out of his content petition.
R3.
My Lord.
You find out the new incumbent, Learned Counsel. You were appearing earlier for respondent 3.
All the respondents.
All the respondents. Okay. Mr. Gauhati, Learned Counsel, appearing for the respondents, submits that the respondent number 3 has been transferred out. So at this juncture, the Learned Counsel for the petitioner, Ms. Upangnanda Longchar, prays that she may be allowed to file an IA for impeding the new incumbent who has come in place of respondent number 3. So prayer is allowed. The petitioner shall file the required IA within a period of 1 week from today.
Lordship, make it 2 weeks.
Okay. 2
Lordship,
weeks.
the new incumbent, he has not joined so far. Anyway, he will be joining within this week, I think.
Then in that case, 2 weeks, yes, in 2 weeks, at least after 2 weeks, yes.
Obliged, Lordship.
May I please, Lordship? Lordship, I'd like to mention item number 7, Madam. Lordship, I'm making mention on behalf of N. Mujay, for respondent number 2 informant, who's the amicus curiae, who's not indisposed today, Madam.
I'm for amicus.
Oh,
He is for the victim's family.
Oh, for the victim, yes, and you are for the appellant.
Amicus, yes. I'm appearing for accused as amicus.
Okay.
Lordship,
N. Muzi is for 2 and 3.
Yes, victim.
2 and 3, victim, okay. When does he want?
on a conscious prayer this meeting.
My Lord, if it is not today, otherwise I'm prepared to argue today. If not today, then after 2 weeks, my Lord. If it is subject to
On what
convenience-
ground? On what ground?
He's indisposed today, Madam.
Indisposed.
Yes.
Learned Counsel, Mr. Medovero, makes a mention on behalf of Mr. N. Muzwi, appearing for respondent number 2 and 3, to list the matter after
If it is possible, Your Honor, 17, is it convenient for the court?
17.
Fixed date is 17.
No
17.
objection.
To just instead of 2 weeks, you say to list on 17th March 2026 for hearing, as the counsel is indisposed today. So the learned counsel, Mr. learned amicus curiae, Mr. Azo, has no objection. List on 17/3.
Much obliged.
Much obliged. Lordship, I can beg to mention item number 8, Madam. Lordship, here the leading counsel from Gauhati has some personal difficulty today, Madam. So on a consensus prayer, I've taken the consent from the other party also. If this matter can come up on
Who's
10th,
the leading counsel?
N. Dasgupta.
In the
Yes. So if this matter can come up on 10th of next week,
10th.
10th of March next week.
Learned
Tuesday.
counsel, Mr. Medovero, makes a mention on behalf of the leading counsel, Mr. N. Dasgupta, who is an outstation counsel, and prays for listing the matter on 10/3/2026. Learned amicus, Mr. Sentianger, appearing for the victim, appearing for the victim, has no objection. List on 10/3. Yes.
Much obliged, Lordship.
Deeply obliged.
May I please,
Yes.
I beg to mention item number 5 and 6.
Yes.
Leading counsel propose, let it be passed for the Lordship.
Pass over for the day. Pass over for the day.
Yes, Lordship, on Thursday.
Thursday? Oh yes, tomorrow is it's a holiday. Yes, so it can come up on Thursday will be 5th. Yes, on the prayer of the parties, list the matter on 5/3 for hearing. Yes,
May it please your ladyship, I may be permitted to move an unlisted matter, Lordship.
what is it about?
I filed it yesterday, but it's not reflected in the cost list. It's a subsequent bail application, and there is a violation of procedural safeguards in regard to grounds of arrest. So there is an urgency.
Okay, let's see if it's filed. Give them
Obliged,
the mention memo. Yes. But motion matters, you need to mention before code number 1 actually. All motion matters. And if code number 1 directs it here, then we will take it up. Okay, you mentioned that.
Lordship.
My
Yes,
Lord,
yes.
I filed an anticipatory bail application this morning. Although unlisted, the matter may kindly be heard.
No, that also, motion, please mention in court number 1.
My Lord.
Please, Your Lordship. Lordship, I beg to mention item number 2, Lordship. Here I am appearing for respondent number 4. Lordship, please release the matter after 3 weeks, Lordship.
R4.
Lordship.
Learned Counsel, Mr. Vijay Momi, appearing for respondent number 4, prays for how much
3 weeks' time.
3 weeks' time to receive instruction.
Lordship.
To receive instructions. So,
May I proceed, Lordship?
Yes.
My apologies for interrupting. Lordship, this matter has been pending for quite some time. And in fact, Lordship, the writ was disposed in the year 2024. And
What
till
is the
now,
matter?
Lordship, this is just to pay the minimum pay of scale to the petitioners.
Scale of pay.
Yes, Lordship. So,
Is it being processed or?
To grant the
What is
latest
going on?
ROP, Lordship. Lordship,
Lordship, here I am for respondent number 3 and 5. So I entered appearance only on November last year. So Lordship, even me also, I need to obtain instructions.
Okay,
This
you get
matter.
instructions.
Yes.
And if it's being complied, till what time it will be possible? Learned Counsel, Miss V. Shukri also appears for respondent number 3 and 5.
3 and 5.
3 and 5 and submits that she has entered appearance only recently and wishes to get instruction. So, Learned Counsel for the petitioner, Miss Mika, is present and submits that the matter has been filed in the year 2025 and till date the instructions have not been received, and she prays that the matter may be listed. No, and she prays that the respondents may be granted a short time. So accordingly, list the matter after 3 weeks. After 3 weeks.
much obliged, Lordship.
Maybe this, Your Lordship,
Yes.
I beg to mention item number 9. I'm on behalf of Sir M.D. Wapang.
Yes.
Your Lordship, kindly fix this matter on 9th of this month.
Learned Counsel, Ms. Such and Such, appearing on behalf of Mr. Imti Wapang, prays for listing the matter on 9/3. Learned Counsel for the appellant, Ms. Such and Such, is present and has no objections. List on 9/3. Yes.
For motion, item number 11.
May I please, my lord. My lord, this is a Zima petition filed by the petitioner for the release of his vehicle Bolero.
Who's appearing? PP? You have served
Last week I
notice.
served the copy to the government, my lord.
The instant application has been filed under Section 528 of the BNSS, seeking release of the petitioner's vehicle bearing registration number such and such. You just check from the cost title, okay? Engine number such and such, which was seized in connection with special case number 21 of 2025, arising out of narcotic cell PS case number 10/2025 under section 21C of the NDPS Act, read with section 3, clause 5/61, clause 1, A1112B of the BNS. So, the learned public prosecutor, Mr. Tiba Pom, has accepted notice on behalf of the state respondent, and hence no formal notice is called for. So, list after, when can you obtain?
My lord, at least 2 weeks, my lord.
At least 2 weeks.
My lord.
This is Kohima case, I think.
Yes, my lord. It's just 10 minutes away from here, narcotic cell. And this is the subsequent petition. So I must be ready with the
10 days, we'll
documents.
give them 10 days.
Not to.
List on today's 3rd, 12.
Okay, my lord.
List on 12/3/2026, on which date the public prosecutor shall obtain the updated case guide. Yes.
Much obliged, my lord.
Item number 12.
May I please, Your Lordship? This matter pertains to non-compliance of this Honorable High Court's judgment and order dated 22/11/23, passed in writ appeal number 14 of 2019.
Where is the judgment page?
Page 50, Your Lordship.
50.
Yes.
No, the direction was given by the single bench, isn't it?
Yes.
Salary, to pay the salary.
Yes, Lordship.
Okay. The instant application under section 11 and 12 of the Contempt of Courts Act 1971, read with Contempt of Courts Gauhati High Court Rules 1977 and Article 215 the Constitution of India, has been preferred by the petitioner, alleging willful and deliberate disobedience of the judgment and order dated
22/11/23.
Wait. Judgment and order dated 6/9/2019, passed in WPC 162K of 2015 and further upheld by the division bench in writ appeal 14 of 2019. Stop. Heard Learned Counsel for the petitioner, Ms. Such and such. It is stated that by judgment and order dated 6/9/2019 in writ petition 162K of 2015, this court had directed the respondents to pay the salaries of the petitioners for the period 1/5/2012 to 29/4/2015 within a period of 3 months from the date of receipt of the certified copy of the order. Stop. A copy of the This order has been further upheld by the division bench in writ appeal 14 of 2019, judgment and order dated 22/11/2023. Stop. It is also stated that a copy of the judgment and order has been served on the respondents by a letter dated 27 March 2024. Stop. However, till date, the respondents have not complied with the said direction. Hence, the present petition has been filed. Stop. Para. Issue notice returnable within 4 weeks. The petitioner shall take steps for service of notice on the respondents number 1 and 2 by speed post as well as usual process within 3 working days, at least after 4 weeks. Yes.
Much obliged.
For admission, item number 1.
May it please my lord. The petitioner herein is the brother of the accused, the convict. And through this revision petition, he has assailed the judgment and order by which the convict was awarded punishment under POCSO and IPC, under POCSO section 8 for sexual assault and for outraging modesty of a woman under 354A. Lordship, the petitioner is primarily before
Lordship,
this.
if I may, if the audio can be.
Yes, yes, this is a POCSO case.
Yes, Lordship.
Just tell them.
Thank you. May I proceed?
1 minute, 1 minute. Why is this filed as a revision?
Lordship, because I'm assailing the legality of the judgment, that the statutory provision under POCSO 42 clearly sets an embargo whereby the trial court, POCSO court, could not have punished, awarded punishment under both laws, Lordship, not delving into the merit of the case. And that is one ground on which I'm before this Honorable Court. And the second ground only is that, therefore, minority is not proved, therefore, conviction under POCSO cannot be sustained.
Okay, thank you. Yes, you can continue.
Lordship, the paper book has been prepared, but I could not find the copy of the FIR. So if my Lord could kindly refer to the appeal memo at page 41. The FIR is there. Page 41, my Lord.
Wait, please, my lord.
We have received the reports, no?
Yes, Your Lordship, I've received the CD, Your Lordship. However, Your Lordship, the charge sheet has already been filed.
Yes, yes. I think this is the scanned copy. Trial court records.
Okay.
Yes.
May I please, my lord? My lord, we have.
When were you arrested? When were you arrested?
I was arrested on the 1st of September 25.
1st September 2025.
Yeah, 1st 9th 2025. My lord, brief facts. A complaint was lodged by the mother of the victim on the 31st 08 2025 at around 2:30 p.m. Alleging that the accused has committed sexual assault, molestation against her minor daughter, who is 7 years and 11 months only. Thereafter, I was arrested, picked up from my residence.
Just go to the grounds on which you are praying for bail.
Straight to the ground, my lord. I have applied bail petition before the court below for 2 occasions. However, it was rejected. And
Let us see the other 2 orders.
Order
Orders
annexed
of rejection.
annexure B, page number 13 and 15. My lord, this is the first order. I
Page
applied
13.
bail
Yes.
in the first occasion on the medical ground. The court had rejected on the ground that the sickness of my health was not grave, and that is why it was rejected. However, my lord, in my para number 6, page number 4 of my petition, still I could not avail the facility advised by my doctor, CT scan as well as MRI, because that facility is not available in the district hospital Mokchong. Until today, I could not avail that facility. But the court below had rejected my first bail petition. The second petition was also rejected by its order dated 4/12/2025, page number 16 and 17, my lord.
This one also medical ground.
That was on the ground that I was not informed the ground of arrest. Ground of arrest. My lord, in the order, the court below clearly mentioned that page number 17, my lord.
Yes.
Page number 17. In
it's ready. I'm hearing it. Let's hear this.
For motion from the supplementary cost list, item number 13. Ajas Salim versus State of Nagaland.
We'll have to fix it another day. The instant application under section 483 of the BNSS has been filed, praying for release of accused Ajaz Salim Sheikh alias Ajaz Salim Bai Sheikh in connection with GR number 153/2024, corresponding to State Crime PHQ Kohima case number 0003/2024 under sections. You just see from the hostel, okay? Stop. The learned PP has, yes, but will issue notice only.
This
Yes.
matter being, there is a violation of grounds of arrest.
For that, we need to see the records, na?
Yes, my lord.
Yeah. Learned counsel for the petitioner, Mr. T. Kazri is present, as well as Mr. Tiba Pong, who has accepted notice on behalf of the learned PP, who has accepted notice on behalf of the state respondent. List on
12 March.
okay, 12 March 2025, on which date, the 2026, on which date the learned PP shall produce the case diary along with all records. Okay, so mainly you have to produce that format.
Okay.
We have to see whether it has been served. I think that's.
Yes, my lord.
I'm obliged.
Much obliged.
For motion, item number 14. Chumlan Thang Kikon versus State of Gujarat.
Transit bail, I think, huh? None appears for the petitioner when the matter is called. List on day after 5th.
For hearing, item number 10.
Yes, what is this?
Lordship,
Oh, freezing of account.
yes. My ground is this account of the petition has been freezed in connection with an NIA case which is pending before the special judge Dimapur.
Okay.
My ground is one that under the UAP Act, there's a procedure for freezing or seizing any property. That provision has not been followed. Actually, in brief, the facts. On 28/2019, 4 persons were arrested by a special operation team of Dimapur police in Dimapur. And a sumoto FIR was filed on 21/8/2019. Allegation is that these people are involved in extortion in and around Dimapur. After about a month, on 13/9, initially the sections were 384, read with 34 IPC only.
384 and 34. Yes.
My lady, may I just narrate the facts?
Yes,
then
yes.
go to- Then on 13/9/2019, the Ministry of Home Affairs directed the NIA to take up the matter.
Okay.
Then the NIA on
Initially, it was taken up by the police.
Nagaland police. Then on 17/9/2019, NIA filed an FIR and section 13 and 20 of UAP Act was added. And pursuant to that too, a C case 10 of 2019 was filed before the registered before the special judge Dimapur. In December 2019, my lord, this petitioner is not an accused in the case.
Okay.
He's not an accused.
Okay.
allegation is, charge sheet also has been filed on 14/2/2020.
Charge sheet filed
On 14/2/2020.
14 to 2020.
2 persons have been charge sheeted. Initially, there were 4 arrested, but only 2 has been charge sheeted. Petitioner has never been arrested, is not an accused in the case. But the allegation is some bank accounts, including mine, has been used by accused number 2 to send money to accused number 1, who is a member of the NSNIM. Therefore, when the charge sheet was filed, Section 13 and 20 were omitted of the UAP Act, and it has been filed under Section 17 UAP Act and Section 384 IPC.
Section 384
And
IPC.
120B. 384,
IPC
120B,
120B,
IPC, and 17 of the
17
UAP Act. So 17, we are concerned with Section 17. 17 is terror funding.
Yeah, the UAP Act. Yes.
17 is terror funding. In December 2019, Manu, this account, my account, 2 accounts, one in the State Bank of India, Kunsa branch, and the other at HDFC, Tinsukia branch, were freezed on a letter written by the NIA. That is in 2019, Manu, December 2019.
Kunsa branch and HDFC. Okay.
I waited hoping that it will be defreezed once the investigation is complete and trial process, but it has not been done. Therefore, I wrote a letter. I wrote a letter asking the reasons or the basis for freezing these bank accounts. My lady, I was furnished with these 2 letters at page 63 by the banks, who are the respondent number 5 and 6. Respondent number 5, from the respondent number 5, I got a letter on 5/5/2025 saying that with reference to your letter dated such, we have to state that your account, MS Atwa Enterprise, my lady, I am a proprietor of this firm, I'm a contractor, government contractor. Account number such was stopped by NIA Kolkata on the basis of letter number such dated 19/12/2019. This is from the SBI. From the other bank, I also received a letter, my lord, that is at page 64, letter dated 10th April 2025.
Yes.
In regards to your letter number dated such and such, seeking information about the status of account number such in the name of MS Atwa Enterprise, we would like to inform you that the account number such was put on debit block. This is notice received from National Investigation Agency, Kolkata, having reference number such. This is the case number, dated 20th December 2019. The above certificate is issued at the specific place of the customer without any extra liability. So, the reason for freezing. The reason is, and I has told them to freeze these accounts. Now, my lady may just briefly take this honorable court through the FIR. Page 17 is the FIR, sumoto FIR filed by the police, Dimapur police. Well, I might not waste the cost time, and this is not relevant in this case. So I'll just flip through this is the annex, FIR. This is dated, this was filed on 21st/8/2019.
Your name is?
I'm not there. I'm not an accused.
Your name is Apung Kois.
Yes, I'm Apung Kois.
Apung Kois, yeah. Okay.
Then, next page, the charge sheet filed by the page 18 is the, did not get the first page. The FIR filed by the NIA on 17/9/19, page 18.
Page?
19. 18, I'm sorry, 18.
Page 18.
Don't have the...
Starting from this address such and such.
Yes, starting from that only, and then paragraph 12 is the reason for filing this FIR. Then, my lady, may kindly come to the order, page 21. That is the order dated 13/9/2019 I was referring to. This is the direction to take up the case by the NI. And my lady,
And in the charge sheet, is there any mention
I'm coming to the
about
page
your
22.
involvement?
Page 22.
Page 22.
Page 22 is the charge sheet. My lady, may kindly come to page 23. The provision of law involved. 120p, 134, 384, and section 17 of the UAP. Column 4. 29, accused. Oh, page 20. Page 29. My lady, the relevant portion regarding this account, page 29, the last para. Investigation also revealed that accused Jai Kishan. So accused number 2.
Accused Jai
Accused number 2 having power of attorney of different
Para, which one?
17.6.
17.6.
Investigation also revealed that the accused Jai Kishan shall not
got huge
financial benefits. Of different firms have not only got huge financial benefits by doing the government works in the name of the sole proprietorship on firms, but also sent large amount of money to the account of accused such and such. This accused number 1, and also to the account of accused number 1's wife, such and such.
True
Through banking channels from accounts of different properties such as Lakwa and MS Atwa Enterprise. So this is the allegation, my lady. So basically this is repeated again and again, these allegations, that these accounts were used to send money to accused number 1, who is a member of the NSNIM. Then my lady may kindly come to page 33, who are the accused. Accused number 1 and 2. 3 and 4 have not been charged, and I'm also not there, never been an accused in this case. So basically, these are the relevant facts to the present case. My lady, now, may I straight away go to the points of law involved? My lady,
Yes.
Section 2. My lady, may I kindly see section 2.1H. 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 2.1H.
2.1H.
Definition of property.
Property.
Property means any property, assets, or of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and legal documents, deeds, and instruments in any form, including but not limited to electronic or digital, evidencing title to or interest in such property or assets by means of bank credits, traveler checks, bank checks, money orders, shares, securities, bonds, draft letters of credit, cash, and bank account. May kindly note that bank account, including fund however acquired. So therefore, bank account is also a property. And therefore, when this is a property, what is the procedure now? May kindly come to 25. For a moment, may I just read section 17 also? What are the provision in law? Whoever in India, in foreign country, directly or indirectly raises or provides fund or collects fund, whether from a legitimate or illegitimate source, from any person or persons, or attempts to provide to or raises or collects fund for any person or persons, when such funds are likely to be used in full or in part by such person or persons, or by terrorist organization, or by a terrorist gang, or by individual terrorists, or commit a terrorist act, notwithstanding whether such funds were actually used or not used for commission of such act, shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to prison with life and shall also be. So this is the offense involved. of this. Now, my section 25. My case is based on this.
Section 25.
Powers of the investigating officer and designated authority and appeal against orders of designated authority. My lady has already seen property also includes bank account.
Yes.
If an officer investigating an office committed under chapter 4 or chapter 6, so 17 is under chapter 4, has reasons to believe that any property in relation to which an investigation is being conducted represents process of terrorism, he shall, with the approval in writing of the Director General of Police of the state, in which such property is situated, make an order seizing such property. And where it is not practicable to seize such property, make an order of attachment directing that such property shall not be transferred or otherwise dealt with, except with the prior permission of the officer making such order, or of the designated authority, before whom the property seized or attached is produced, and a copy of such order shall be served on the person concerned. Therefore, my lady, before they seize, before they freeze their account, direct written permission approval of the Director General of Police of the state. Then, 2. The investigation officer shall duly inform the so here my case is that this such a written approval was also not taken. Number 2, investigating officer shall duly inform designated authority within 48 hours of the seizure or attachment of such property. I'm saying this also has not been done because there's nothing. The designated authority before whom the seized or attached property is produced shall either confirm or revoke the order of seizure or attachment so issued within a period of 60 days from the date of such production. So once it comes before the designated authority, he can revoke or confirm it within 60 days. This has not been done. Provided that an opportunity of making a representation by the person whose property is being seized or attached shall be given. So before he confirms the order, the designated authority has to give an opportunity to me to make a representation. I've never been informed. This opportunity was never given. Even no order was passed by the designated authority. 4 is not relevant. This is related to immovable property. And this is number 5 is relating to cash.
5 is cash.
So, kindly come to number 6 now. Any person agreed by an order made by the designated authority, if the designated authority makes an order of confirmation, may prefer an appeal to the court within a period of 30 days from the date of receipt of the order. And the court may either confirm the order of attachment of the property or seizure, so make or revoke such order and release the property. Here, my lady, once the designated authority, in this case, confirms the seizure.
Who would be the designated
Yes,
authority?
the joint secretary is mentioned. Joint secretary is the designated authority. Means such officer of the central government not below the rank of joint secretary to the government or such other officer of the state government below the
Not below the rank of secretary.
In this case, my lord, is the joint secretary of the Ministry of Home Affairs. So, my lady,
Yes. Yes.
So, my lady, first of all, it's an approval from the Director General of Police. Then the investigation seizes the property, and within 48 hours, this is placed before the designated authority. My lord, under Section 25, it should be placed before the designated authority, and the designated authority should confirm or revoke the order within 60 days. But first, an opportunity has to be given, and if the order has been confirmed, then I can only go in appeal under 6 to the court. Here the court means the special court.
The special court.
I have to go there only. But when no such order is passed, nothing is mentioned in the act. There's no appellate's provision provided. Therefore, contravention of the statutory provision, specific statutory provision of a special law, my only remedy lies before the writ court. My lady, I'm not saying they don't have the power. They have the power. They have the power under Section 51A also for freezing. But that is also by the central government, not by the NI, investigation of the authority. But no such order was passed. But even then, there's a procedure prescribed by law that this is the method so that the power is not abused, and that has not been done. My lord, this fact has not been disputed by the NIA. This fact has not been disputed by the NIA. They are saying, my lord, they have raised certain other grounds, but before I go to that, before I answer their contention, my lord, list of authorities. My lady, this is regarding PMLA. Similar provisions are there. Supreme Court says when the procedure prescribed has not been followed, it has to be washed. Yes, direction was given to defreeze the account.
This is your copy. Brother?
It's not from Paraphone. The instant appeal arises out of proceeding initiated by respondent number 4 against the appellant under PMLA. The analogous matter which was considered by the High Court along with the writ petition, which is the subject matter hearing related to action initiated by Central Bureau of Investigation for the alleged predicate offence, and in the instant proceeding it's a follow-up of the same. It is in the background that the enforcement directed or in order to track the money trail relating to the predicate offences and prevent the laying of the same was initiated and the proceeding under PMLA. In the said process, the Deputy Director of Enforcement through communication data such addressed to anti-money laundering officer, respondent number such and such, banks instructed them that the account maintained by the appellant company be repeat freeze stop operation until further orders. What with immediate effect? It is in this light the appellant claiming to be aggrieved while WP number such and such before the High Court seeking for issuance of appropriate writ to quash the communication data sets issued by the defeat freezing. Account number such that is account number maintained by respondent number 1, account number such by respondent number 2, account number maintained by respondent number 3. The appellant in the record also prayed that the respondent be directed to defreeze the account to which reference is made. The High Court considered the matter in detail and has taken into consideration the object with which the PMLA was enacted and the validity of that being considered by the High Court in decision referred to in the course of the order. Permissibility and scope of the parallel proceeding under Section 3(4) of the PMLA was averted to in detail and upheld the action. Insofar as the reasoning adopted and the conclusion reached by the High Court with regards to the power and competence to initiate the proceedings under PMLA in view of the action taken for predicate offence, the High Court was very much justified. However, the High Court, having held that the impure communication was with competence of our jurisdiction, ought to have examined whether due process as contemplated under PMLA was complied with so as to make it valid and sustainable in law, though the power under the Act was available. As already noticed, the consideration to be made in this appeal is therefore limited to the aspect of defreezing the account. More particularly, keeping in view the requirement of the appellant to make the statutory payment even if the freezing of the account is one justified. While adverting to this aspect of the matter, what cannot be lost sight of is also the fact as to whether the power available to the competent authority has been exercised in the manner as contemplated under the PMLA. The Directorate of Enforcement in the complaint affidavit has taken contradictory and inasmuch as, while explaining the need to freeze the account, has stated that stop operation was requested to stop the further daring the evasion of proceed of crime and to safeguard the proceed of crime, which we notice is a power available under PMLA. But in the complaint affidavit, it is strangely stated that the same has not been done under Section 17(1) of the PMLA. However, in contrast, it has further with regards to power available under PMLA, that PMLA being a stand-alone enactment and independent process, where under Section 71 of the PMLA has an overriding effect over other laws. Irrespective of the stand taken, the power exercised by the competent authority should be shown to be in the manner as being provided in law. In this case, under PMLA, To appreciate this aspect, it would be appropriate to refer to section such and such under wherever the freezing of such property or record is also available. My lady, can we skip this provision? Section, para 8. A perusal of the above provision could indicate that the prerequisite is that the director of such or such other authorized officer, in order to exercise the power under section 17 of PMLA, should, on the basis of information in his possession, have reasons to believe that such persons has committed an act relating to the money laundering, and there is need to seize and record of all property found in the search. Such belief of the officer should be recorded in writing. Subsection such and such provides that the officer authorized under section 1 may make an order to freeze such record of property where it is not practicable to seize such record of property. Subsection 2 provides that the officer shall forward a copy of the recent recorded head along with material in his possession to the adjudicating authority in a single level. Subsection 4 provides that authority seizing or freezing any record or property under subsection 1 or 1A shall within a period of 30 days from such seizure or freezing as the case may be filed an application before the adjudicating authority requesting for retention of such record or properties. For the purpose of 10, the scheme of PMLA is well intended. While we seek to achieve the object of preventing money laundering and bring to book their offenders, it also safeguards the right of the person who could be proceeded against under the Act by ensuring fairness in procedure. Hence, the procedure, including timeline, is provided as to ensure that the power is exercised for the purpose to which the officer is vested with such power, and an adjudicating authority is also kept in the loop. In the instant case, the procedure contemplated under section 17 of the PMLA, to which reference is made above, has not been followed by the officer authorized, except issuing the imprint communication dated 15/5/2020 to the PMLA officer to seek freezing. No other procedure contemplated in law is followed. In fact, the imprint communication does not even refer to the belief of the authorized officer, even if the same was recorded separately. It only states that the officer is investigating the case and seeks for relevant document, but in the tabular column abruptly states that the account have to be debit freeze stop operation. It certainly is not the requirement that the communication addressed to the bank itself should contain all the details. But what is necessary is an order in the file recording belief as provided under section 17(1) of the PMLA. Before the communication is issued and thereafter the requirement of section 17(2) of the PMLA of the freezing is made is complied with. There is no other material before the court to indicate compliance with section 17 of the PMLA. More particularly, recording of belief of commission of the act of money laundering and placing it before the adjudicating authority or filing application after securing freezing of the account to be made. In that view, the freezing or the continuation thereof is without due compliance with legal requirement and therefore not sustainable. 11. Mr. Such and such, Attorney Solicitor General made a subtle attempt to contend that the power of seizure is available under section 102 CRPC, which has been exercised, and as such, the freezing of the account would remain valid. We are unable to appreciate an exception's contention for more than one reason. Firstly, as noted, it has been the contention of Respondent number 4 that PMLA is a stand-alone enactment. If that is so, and when such enactment contains a provision for seizure, which includes freezing, the power available therein is to be exercised, and the procedure contemplated therein is to be complied with. Secondly, when the power is available under the special enactment, the question of resorting to power under general law does not arise. Thirdly, the power under section 102 CRPC is to the police officer during the course of investigation, and the scheme of provision is different from the scheme under PMLA. Further, even subsection 3 to this section 102 CRPC requires the police officer shall forward report to the seizure to the magistrate having jurisdiction, in compliance with which is also not shown if the said provision was invoked. That apart, the impugned communication dated to the such does not refer to the power being exercised under the code of criminal procedure. 12. The action sought to be sustained should be with reference to the contents of the impugned order communication, and the same cannot be justified by improving the same to the contention raised in the objection statement or affidavit filed before the court. This has been simply laid down in the Mohinder Singh Deals versus 3 court. Lady, we can skip this, my lady. May kindly come to 14. 14. This.
Let's continue at 2.
My lord, I have a
Yes.
prayer.
Yeah.
Earlier, when item 14 was called, I was unable to appear. The matter has been refixed on 5th March. I humbly pray that the matter may be heard today. It is an
That
anticipated bail.
unlisted motion.
Yes, my lord.
Okay. To
Pledge, my lord.
Actually, Manila is sobat bagus tuh. Kahulu. Nah, nanti mana? Ya, dia malu kan dia tuh.
Senyap.
Hello. Hello. तू दिन को तू दिन बचना क्या तो इधर हो गए चलो चलो ठीक है For motion from the supplementary cost list, item number 14.
Yes.
My lord, shall we proceed without the prosecution?
Where are they? You have given notice.
Yes, my lord. Shall I call for the prosecution?
Wait. Okay, please call. Whoever is appearing. When are you supposed to appear?
In this regard, my lord, I've received 2 summons. Firstly, I was supposed to appear on the 16th, and I was also supposed to appear yesterday. Shall I proceed, my lord?
Yes, please do.
This is an application under 482 BNSS, praying for interim or transit anticipatory bail, my lord. The facts of the case very briefly. So I received a summons dated 6th of February. Now, as per the summons, it is stated that 2 accused has been apprehended from Gujarat, both permanent residents of Gujarat, and it was ascertained that these 2 accused persons were in possession of bogus arms license. Now, during investigation, it was also ascertained that these bogus arms license were issued from the office of the arms branch in the Deputy Commissioner's office, Wokha, using the petitioner's user ID. The petitioner here, he is an LDA, currently posted in the arms branch, Deputy Commissioner's office. So accordingly, the petitioner, he has been called to witness before the investigating authority in person. Now, my lord, as soon as I received the first summons, I've taken every steps possible to communicate with the investigating authority and also to express my difficulties to appear in person. And the reason being, my lord,
User ID in there. Actually, that means it is given, it is procured online.
I believe so, my lord. So, my lord, as soon as I received the first summons, I've taken every steps to communicate with the investigating authority. So, on the 14th of February, via electronic communication, I forwarded some documents, which includes, firstly, an application praying for leave from physical appearance due to medical grounds. Secondly, I've also forwarded documents showing my medical history. And thirdly, I've also submitted a written statement categorically explaining the functionings of the arms branch office. However, my lord, this electronic communication was not replied to. Therefore, on the 16th of February, I took the trouble of forwarding these same documents via registered post to the concerned authority. And as per tracking records dated 25th of February, which my lord will find at Annexure F, page 23 and 24, my lord. So as per this tracking record, it is shown that the said parcel has been successfully delivered to the concerned authority. In the meantime, I received another summons, the second summons, directing me to appear in person, which was yesterday, my lord. And therefore, my lord, the grounds on which I'm bringing for this interim bail, this transit and distributory bail, I've already stated in the facts, but for the sake of repetition, my lord. Firstly, as per the medical documents, annexed in Annexure D, page 20 and 21, my lord, the medical records. It shows that I've been diagnosed with hepatitis C.
Okay. We'll give you a transit bail for a limited period, and within that time you go and apply before the competent court.
My lord, now with regard to the
Whatever
duration.
it is, you have to appear.
Yes, of course. But my lord, I have a humble prayer with regard to the duration of the interim bail. It is very difficult for me to travel at the moment.
60 days?
My lord, if it can be extended to 3 months.
No. I think that is too much. 60 days will do.
If my lord may kindly peruse the medical certificate, my lord, at page 20 and 21.
2021.
Now, page 21, my lord, precisely. Now, this medical certificate was issued to me by the District Hospital, Wokha. This was issued on the 14th of February, my lord.
What is your ailment?
I've been diagnosed with hepatitis C. And therefore, I'm in constant need of medical evaluation, my lord. Now, as per this certificate, I've been advised to take 3 months of leave, my lord, 3 months of rest. And therefore, on the strength of this medical certificate,
Okay,
my
90
humble
days,
prayer.
90 days then, yes.
Much obliged, my lord.
The present application under section 482 of the BNSS has been filed praying for interim anticipatory bail / transit bail in anticipation of arrest, filed by the present petitioner, apprehending arrest in connection with the FIR number 2/2025 filed before the ATS under bracket Anti-Terrorism Squad, close bracket, Gujarat Police Station. Stop. Learned PP for the state of Nagaland is present. Learned PP Mr. Tibapong for the state of Nagaland is present. Stop. Where I've heard learned counsel for the petitioner, Mr. Sergeant Search. Stop. The case of the petitioner, the main contention of the petitioner is that he had received a summons dated 6/2/2026 from the office of the Additional Director General of Police Anti-Terrorist Squad, Gujarat, Ahmedabad, stating that an investigation is being carried out by the ATS Gujarat Police Station in connection with the FIR number 2 of 2025. So, the petitioner thereafter sent what did you send after that? Sent an application for leave from physical appearance due to medical reasons, enclosing the medical reports and also a written statement categorically explaining the functioning of the Arms Branch Office in the office of the Deputy Commissioner, Wokha, Nagaland. Stop. The petitioner did not receive any reply to the said electronic communication dated 14/2/2026. Therefore, the petitioner sent a parcel via India Post on 16/2/2026 addressed to the investigating agency containing a leaf from physical appearance, copies of medical documents highlighting the petitioner's medical state, and a copy of a written statement categorically explaining the functioning of the arms branch in the office of the Deputy Commissioner, Wokha. Stop. The tracking of the parcel shows that the same was delivered successfully on 24/2/2026. Stop. Para. However, the petitioner received another fresh summons dated 21/2/2026 from the office of the Additional Director General of Police, Anti-Terrorist Squad, Gujarat, Ahmedabad, directing the petitioner to appear in person before the IO at the office of ATS Gujarat Police Station, Gujarat, Ahmedabad on 2/3/2026 at 12 hours. Stop. apprehending arrest, the petitioner is before this court praying for interim / transit anticipatory bail. Stop. Okay. This court has perused the documents enclosed along with the petition and also the medical reports of the petitioner. The court has also perused the summons issued to the petitioner, and in view of the same, this present petition is allowed. Stop. The petitioner is granted granted transit anticipatory bail for a period of 90 days, within which time the petitioner shall approach the court of competent jurisdiction for anticipatory bail as envisaged under the law. Stop. It is also provided that in the event of arrest, the petitioner shall be released on bail on execution of a bail bond of rupees 30,000 to the satisfaction of the arresting authority. So, with the above directions, the petition is disposed.
Much older.
I was reading the out of circuit case.
Yes.
I continue from paragraph 14.
This court, yes.
This court has time and again emphasized that if the statute provides for a thing to be done in a particular manner, then it has to be done in that manner alone and in no other manner. Amongst others, in a matter relating to the presentation of an election petition as per the procedure prescribed under the Patna High Court rules, this court had an occasion to consider the rules to find out what could be the valid presentation of an election petition in this case. No manner that we can skip this. 15. Apart from the above consideration, what has also engaged the attention of the scholars with regards to the principle of the appellant regarding the need to decrease the account to enable the appellant to create the statutory leaves. The appellant has in regard applied to the certificate mentioned by the Chartered Examiner, which indicates the amount payable towards such and such. Deduction including amount of such. Since we have indicated that freezing has been done without due compliance with law, it is necessary to direct respondent number 1 to 3 to defreeze the respective accounts and clear the check issued by the appellant drawn in favor of the competent authority towards such and such. And subject to the availability of the funds in the account concerned. It has to mention that if any further amount is available in the account after the payment of such dues, with regards to the same, any action is to be considered taken by respondent number 4 within a reasonable time. It could be open to do so, subject to compliance with the required procedure afresh as contemplated in law. In terms of the above, the communication that is also squashed, we direct the respondent shall defreeze the account bearing upon such and such. So, already, the procedure prescribed was not followed, and therefore, the direction was given to defreeze. And this is TMLA. Similar provision is there under the Act. Now, another case, this is with regards to the concerned Act, that is UAP Act. But, let me kindly come to the Act once. Section 7 may kindly see. There's a provision under Section 7 to prohibit the use of funds of an unlawful association. This case is relating to this, and this is from the Madras High Court. There's a provision for prohibiting the use of a fund of an unlawful association, but there's a procedure prescribed. In this case, the procedure was not followed, and the Madras High Court interfered. May I just read the relevant portion? Let's start from 5, paragraph 5 onwards. Section 3 of the UAP Act empowers the central government to declare any association unlawful through the notification in Official Gazette. In accordance with this provision, the PFA has declared as an unlawful association through the gazette notification that is such. In consequence of the declaration of an association as unlawful, the central government is empowered to pass prohibitory orders against the use of funds of an unlawful association or against any person or who aids an unlawful association with any sort of funds for the sake of convenience. Section 7 of the UAP Act is prohibited below. May I skip this? May I skip this for you? Para 6. Section 7.1 also prescribes the procedure for passing prohibitory orders touching upon the uses of funds of an unlawful association. As per the procedure prescribed there, when the central government comes to a subjective satisfaction that any person aids or assists in an unlawful association with money or is in custody of money, security or credit, which is used or intended to be used for such purpose of the unlawful association, it is mandated to conduct an inquiry before passing a prohibitory order. Admittedly, the central government has not expressed the manner in which they had arrived at subjective satisfaction, apart from relying upon certain documents from the digital device, which advertisement evidences the name PFI alone and not of the petitioner's trust. To the specific stand taken by the petitioner that the trust has no connection whatsoever with PFI and the funds in the savings bank account have never been used for activities of PFI, the respondent were not in the position to substantiate the nexus between the petitioner trust and PFI. When Section 7.1 mandates an inquiry to be conducted before passing the prohibitory order, which admittedly has not been conducted in the present case, the consequential order could be in violation of Article 14 and 21 of the Constitution of India, apart from violating the principle of natural justice. On this sole ground, the European order cannot be legally sustained. I come to 10. The learned additional Solicitor General has also raised a ground of maintainability of the present petition in view of the alternative remedy available under Section 7.4 of the UNPA. In the preceding portions of this order, we have held that the failure to conduct an inquiry before passing the European order would be in violation of the principle of natural justice. This apart, the claim made by the petitioner trusts that the European prohibitory order was never served on them has not been denied by the respondents. It is needless to point out that the prohibitory order could have crippled the functioning of the trust and disabled to fulfill the object of the trust. The freezing of the only bank account of the trust would therefore have caused serious prejudice to the trust. Whenever any cause of action is initiated by the respondent by invocation of Section 7 of the ERP Act, there is a duty cast on them to inform the affected party about the action taken. In other words, such a prohibitory order requires to be served to the affected party, which is crucial since subsection 4 provides for an alternative remedy against the prohibitory action taken. This alternative remedy also provides for limitation of 15 days within which the prohibitory action requires to be challenged. And when the order itself is not served on the affected party, we are unable to comprehend as to how the trust could have availed the alternative remedy in the absence of a copy being served on the trust. Thus, the failure to serve a copy of the prohibitory order on the trust would amount to violation of principle of natural justice. 13. In cases of such and such, are some such decisions where the principle of natural justice have been held to be an exception to the general rule of entertaining petition under 226 of Constitution of India. When the statute provides for an alternative remedy, thus the present writ petition challenging the European order, which is in violation of the principle of natural justice, could be admissible. 14. For all the foregoing reasons, the European order passed by the respondent number 1, that as such is quashed in view of the quashing of the European order. The petitioner's bank account as such stands defrozen. So, my lady, here also, in my case also, there's a specific procedure prescribed by the Act, which is a special law, Section 25. It's not useless formalities, my lady. This has to be followed while seizing any property in connection with the offense under the Act. But this has not been done, so all the actions, therefore the freezing itself is vitiated. My lady, the NIA has not said that they have taken these steps under Section 25. They have not denied that. But what they have said is there's an alternative remedy. Alternative remedy is only when an order is confirmed by the designated authority under Section 3 of 25, Section 25. Then we have to go to the special court. In this case, my lady, no order has been passed.
What about Section 7?
Section
what
7,
is the procedure?
Section 7 is relating to prohibition of fund, of of an unlawful association. Here the organization must be first declared unlawful, which is not the case here. And even then, notice has to be given. My lady, can we read this? Can we read this section then? Section 7? Where an association has been declared unlawful by a notification. That is the first thing that they have to do.
This is with regard to NSC and K, isn't it?
NSC and no IM.
IM, oh, acha.
So this is not attracted at all. Accused number 1 is allegedly a member of the IM. And allegation in the case is that accused number 2 has sent him money through this bank account.
Through this account.
Through this accounts. That's the only. Section 7 is not attracted at all. My lady, may I kindly refer to Bilkis case. It's a bulky one. I've just printed the relevant page only. Paragraph 322 and 233. Before we proceed further, we wish to reiterate that this court has spoken on the concept of rule of law through its various judgment. Rule of law means wherever the state fails to perform its duties, the court would step in to ensure the rule of law prevails over the abuse of process of law. Such abuse must result from inaction or arbitrary action of protecting the true offenders or failure by different authorities in discharging statutory or other obligation in consonance with the procedural and penal statute. Breach of rule of law amounts to invasion of equality under Article 14 of the Constitution. So there's a clear statutory mandate duty upon the investigation authorities to comply with the procedure under Section 25. And another one. This is the Washdu case. My lady, now another ground taken in their defense by the NIA is that this was freezed in the way back in 2019. 2019. And therefore, I've come very late. There's delay. My lady is very well aware, Limitation Act is not applicable to read petitions, but delay and laches, yes. Gross delay and laches. And if interference by this honorable court lead to unsettling, settled things. But that is not the case here. Here, an injury was caused to me in 2019, and the injury still continues till today. My 2 bank accounts have been freezed. I'm a contractor. I'm unable to use my funds parked in the account. My lady, may kindly read paragraph 4. Paragraph 4. You give me which one? Paragraph 4, right? In order to get out of the clutches of Paragraph 27, it is urged that Section 23 of the Limitation Act would apply as a result of which limitation could be saved in the present case. This contention is ineffectively answered by a judgment of 3 judges based in such and such. In this case, this court held as follows. In dealing with this argument, it is necessary to bear in mind that Section 23 refers not only to continuing right, but also to continuing wrong. It is very essence of continuing wrong that is an act which creates a continuing source of injury and renders the doer of the act responsible and liable for continuance of the said injury. If the wrong act causes an injury which is complete, there is no continuing wrong, even though the damage resulting from the act may continue. If, however, a wrongful act is of such a character that the injury caused by it itself continues, then the act continues as a continuing wrong. In this connection, it is necessary to draw a distinction between the injury caused by the wrongful act and by what may be described as an effect of a said injury. It is only with regards to act which can be properly characteristic as continuing wrong that Section 23 can be involved. Thus, considered it is difficult to hold that the Justice Act in denying altogether the alleged right of the Govas are hereditary worshippers and in claiming the obtaining possession from them by the suit in 1992 was a continuing wrong. So, my lady, here, my case is that an injury was caused to me way back in 2019 years, 5 years down the line. But that injury is still continuing. Therefore, there's no delay. Well, I think that this is also on the question of delay. Paragraph 23. Paragraph 23 only. Paragraph 23. With regard to the state that the learned single judge of the High Court did not deem able to inquire with the state whether just and fair composition were paid to the applicant or not, the learned single judge rejected the petition only on the ground of delay. As held by this court is such as such, the delay and measures cannot be raised in case of continuing course of action or if the circumstances shock the judicial conscience of the court. The continuation delay is a matter of judicial discretion which must be exercised judiciously and reasonably in facts and circumstances of the case. As held by this court, it would depend upon the breach of fundamental rights and remedy claim and when and how the delay arose. There is no period of limitation prescribed for the court to exercise constitutional jurisdiction to do substantial justice. Therefore, the only ground, only resistance is that delay. My lady, Article 14, arbitrary, total arbitrary use of power against me. Therefore, my lady, fundamental rights has been violated. This court can invoke its 226 jurisdiction and kindly give me the reliefs. Then, my lady, just short one. This is 25 and 26.
Paragraph 25 and 26.
It is presumed that prior permission has been taken unless the complaint could be established by the state. Maybe there was a delay of 6 years in filing a permission. However, it is well settled that law limitation do not apply to the exercise of jurisdiction under 226 of the Constitution of India. Relief under 226 of the Constitution of India being discretionary, the court might, in the discretion, refuse to entertain the writ petition, where there is gross delay on the part of the writ petitioner, particularly when the relief sought would if granted unsettled things which are already settled. In this case, the respondent petitioner is claiming pension, which is a lifelong benefit. Denial of pension is a continuing wrong. This court also be oblivious to the difficulties of the retired employee in approaching the court, which could include financial constraints. Similarly, my lady, it's a continuing wrong. Last one. Paragraph 15. Paragraph 15. Thus, while it can be said that this court has recognized some exception to the rule of alternative remedy, where statutory authority has not acted in accordance with the provision of the enactment in question, or in defiance of the fundamental principle of judicial procedure, or has resorted to invoke a correction which are repealed, or when an order has been passed in total violation of the principle of natural justice, the proposition is that on such and other similar judgment that the High Court will not entertain the petition of the Constitution of India if an effective ordinary remedy is available to the aggrieved person, or the statute under which the action complained of has been taken is self-comprehensive mechanism for redressal still holds the field. Therefore, when a statutory forum is created by law, so therefore, my lord, if there's a forum, yes. But even in spite of there being a statutory appellate forum, if there's a fundamental violation of fundamental rights, principle of natural justice, which in this case, my lord, there's also I'm also saying that it is also in violation of principle of natural justice, and where there's statutory violation, my lord, honorable court can interfere. But in this case, my lord, there's no provision for an alternative remedy. Alternative remedy is only when an order is passed by the designated authority.
Then against that, you can go to the
special court. I have to go to the special court. If I come here, my lord, then it's not maintainable. But here, the designated authority has not passed down any order. My lady, my case is simple. The NIA has, the investigation agency has the power to freeze any account related to a case, but Director General written approval has to be taken at first. Then within 48 hours, this must be placed before the designated authority. The designated authority must give me an opportunity to make a representation and must take a decision must dispose it off within 60 days. That has not been done. Therefore, entire thing is illegal. That's my question.
Yes.
Lordship, as Mark Twain has said, facts are stubborn things, Lordship. Now, at this stage, I cannot turn.
What did you say?
Facts are stubborn things.
Oh, cha. Okay.
Now, at this stage, my Lord, I can neither turn back the clock, nor can I say that remedial steps will be taken in future, so far as Section 25 is concerned. Because, Lordship, as per me, it all points down to one issue, whether 25 has been complied or not.
That's the only
Yes,
thing.
yes, Lordship.
Yes.
Now, from the records, we have also filed our...
But it is still, the trial is still ongoing, isn't it?
Yes, my Lord, but he is not an accused.
He's not an accused.
Yes, yes.
But if there is prima facie case that terrorist funds were being transferred through his account,
Lordship.
then you can always take steps.
Yes, Lordship, Lordship. But at this stage,
According to
Lordship,
the procedure.
yes, 25, which is a mandatory provision, it has been violated, Lordship. Now, my prayer before this Honorable Court is that we have also filed our affidavit. That issue has been raised in paragraph 12 and 16 of the writ petition. To be fair, Lordship, we have not annexed any records showing that Section 25 has been complied.
No, when there is no complaints, how can you show?
Yes, Lordship, exactly, Lordship. Now, my humble request, Lordship, is that my affidavit, paragraphs 4, 9, in order to save time, Lordship, 9, 21 and 23. Kindly be reproduced as part of my submissions.
21 and
23, Lordship.
and 23.
Yes, my Lord. Even if I say 1,000 things, I'll only be running in circles, so there's no point.
Very fair on your part.
My Lord, I have to be.
Yes. Let us see the prayer portion. Prayer to defreeze and allow the petitioner to operate his farms, accounts, and research in the future. Okay. Yes.
Obliged, my Lord.
Yes.
Appearing for respondent number 6, HDFC Bank.
Okay, yes.
So I have nothing to
For
submit,
you,
my Lord.
nothing much, yes.
Yes, nothing much. We have
Because
filed
you
our...
have just followed the
Yes,
instructions.
we had kept the account under debit block, my Lord, as per the NI letter dated 2012-19, NXRA in my affidavit, my Lord, page 7. And we have...
Affidavit of response.
we have filed an affidavit in opposition.
Tara?
The page 7, my Lord, of my affidavit.
7.
In terms of this letter, we have put the account on the debit block, and we have also annexed one bank statement, that is Annexer B, my Lord, at page 8. And this is the bank statement amount that is being already...
Not legible at all. Anyway, what is this?
This is a bank statement. Whatever amount is there in the account is being reflected here.
Okay.
So that is on the debit block. And that's all. We'll follow whatever my Lord directs us to do. Yes. One prayer, my name may be recorded in that.
Yes, is your name there in the
it's not shown in the cause list.
It's not shown.
Yes, R. Chakraborty.
For R6.
Yes, R6 month.
Learned counsel for the petitioner, Mr. Inti Longjun. Also with Mr. Sentianger, Special PP for the NIA, and also Mr. R. Chakraborty for the respondent number 6. Address disposed of. Okay. Chamber disposal. Send this also. Yes.
We want to follow.
Itu ini logo sir. Itu nanti kaki di mana? Heater भी off कर दो दे. Heater